So, welcome students. Today we are discussing the 100 questions of the Jharkhand Judicial Service 2015. We will do it in a very exact manner. So, please like, share and subscribe our channel for more videos like this. तो चलिए शुरू करते हैं. तो ये है झारखंड जुडिशियल सर्विस का सिविल जज जूनियर डिवीज़न का प्रिलिमिनरी टेस्ट ऑफ 2015. ओके. So I have collected these questions for the purpose of your convenience upcoming exam. Now let's see. Question number 1 says, now if anyone is not aware of the specific syllabus of the Jharkhand Judicial Service, then one must listen that it is general knowledge and current affairs, general English, the code of civil procedure, the code of criminal procedure, Indian Evidence Act, the law of contract and the Indian penal codes. Okay, so these are the law related subjects, and general knowledge and current affairs and general English or comparative English will be there, and from these subjects there will be a question of 100 questions, each carrying 1 mark, and there is no negative marking or negative ranking. Okay, so if anyone does any question wrong, then there will be no negative marking. So let us start. Which of the underlined parts of the given sentence contains an error? Question number 1. One of my sister lives near the India Gate in New Delhi. Now in this question, one of my sister, यहाँ पर लिखा है one of my sister. So उसका मतलब है उसके और भी सिस्टर्स है, तो इसीलिए पार्ट ए पे गलती है. क्या है यहाँ पे? वन ऑफ माई सिस्टर्स होगा. क्वेश्चन नंबर 2, फिल इन द ब्लैंक विद अ सुइटेबल फॉर्म ऑफ वर्ब इन द फॉलोइंग. माई फ्रेंड डैश लिविंग इन मुंबई सिंस 2014. द आंसर इज माई फ्रेंड हैज़ बिन लिविंग. लिविंग यानी कि प्रेजेंट कंटिन्यूअस टेंस में है. सो माई फ्रेंड हैज़ बिन लिविंग इन मुंबई सिंस 2014. Fill in the blank with an appropriate preposition. They belong to the same party but they do not agree on everything. The word millennium refers to a period of 1000 years. Fill in the blank with the suitable choice. Delhi is hotter than Shimla in May. Now coming to this part, question number 6, which of the following is a similar in meaning to that which cannot be read? Which cannot be read means illegible. Okay, select the appropriate choice to fill the blank in the sentence. Tigers are ferocious. Dash tigers are ferocious. Now in this case, though the starting letter, that is T, tigers are ferocious, started with small letter, but that is the trick. Okay, in this sentence no article is required. Tigers are ferocious. Okay, you may have opted for the tigers are ferocious. That is not the requirement here. Okay, tigers are ferocious is an enough and complete sentence. Now identify the type of sentence given below. That is, can you lend me your pen please, question mark. So it is very simple, interrogative sentence. Okay, an ophthalmologist treats the disorders of what? Eye. The word terrestrial connected with the word what? Land. Okay, now question number 11, who appoints the judges of the High Courts of India? That is the President of India. 12, the Quit India movement is held on or started in 1942. Question number 13, deficiency of which of the following vitamins causes night blindness? That is vitamin A. One of the following gases in the is the cause of greenhouse effect. So which one of the following gases? That is the carbon dioxide. Okay. 15, the United Nations organization was formed on 24th October 1945. Okay, now coming to section 16, that is question number 16, the American journal Time has chosen one of the following as the person of the year 2015, that is Angela Merkel. This is the question of which year? Question of 2015. That's why it was relevant in that year. Okay, so that's why I am telling you about reading the the current affairs also. Now For your convenience, I can say that these Times magazine for the year of 2023 selected Taylor Swift, the British singer, female singer, as the what person of the year. Then in 2021, it has selected Ukrainian president Vladimir Zelensky. You all may have heard his name in the news channels, that for the year 2022 it's Vladimir Zelensky, I mean the Ukrainian president, and for the year 2021 it was Elon Musk, the SpaceX, the owner of the SpaceX, okay, the owner of the Twitter, and for the recent time, in the recent times he has bought the Twitter also, okay. Now coming to Amaravati is being made new capital of which one of the following state, that is Andhra Pradesh. Justice Meenakshi Madan Rai has been sworn in as the chief woman judge of the High Court of which of the following states, that is the answer is Sikkim, okay. Now coming to 9, that is question number 19, who of the following is the writer of the book Wings of Fire? It is very easy, that is it is Dr. APJ Abdul Kalam, okay. Cristiano Ronaldo has recently been voted as #1 footballer. He hails from which of the following countries? He hails from Portugal, okay. Now going to question number 21. A magistrate has the power to direct the police to investigate into an offence in CRPC under section 156(3). 22. Under the scheme of the Criminal Procedure Code, non-cognizable offences are private wrongs. Non-cognizable offence, remember that non-cognizable offence are private wrongs. Cognizable offences are public wrongs. Section 159 of CRPC, the magistrate has the power to depute any magistrate subordinate to him to hold a preliminary inquiry, and B, direct investigation by the police officer. Under section 159, the magistrate has both these powers. So the correct answer will be option number C. 24. Under section 167 of CRPC, the nature of custody can be altered from judicial custody to police custody and vice versa. This alteration can be done during the period of first 15 days, okay, during the period of first 15 days. Now coming to the question number 25, cognizance of offence of defamation under chapter 21 of IPC can be taken on a complaint made by an aggrieved person only, okay. So if the offence is of defamation and it is dealt in chapter 21, then the offence of defamation, the complaint can be taken on a complaint, cognizance of the offence can be taken on a complaint made by an aggrieved person. Now joint trial of several person is permissible under section 223 of the Criminal Procedure Code. Rule autre fois acquit and entre fois commit is contained in under section 300, okay. Now coming to question number 28, in which of the following cases the Supreme Court held that the High Court cannot directly entertain bail application of POTA accused, that is Prevention of Terrorist Activities, POTA accused, without its refusal by special court? It is in the case of State of Gujarat versus Salim Bhai Abdul Ghaffar Khan, okay. Now, a legal remembrance cannot be made ex officio public prosecutor. This was held in none of the above cases. The answer is none of the above. Legal remembrancer is a person of the government who represents the government in legal matters. Okay. Now, 30 urgent cases of nuisance or apprehended danger falls under section 144. In our class, in our CRPC class, we have discussed that whenever we are reading CRPC section 144, urgent word is very important to remember, okay. Now coming to section 31, when warrant also cannot be executed, the court may proceed under section 82 and 83, that is proclaiming that person as an absconder, and 83 deals about attachment of the property. These procedures will be taken up if the arrest warrant cannot be executed. Now plea bargaining, a new chapter was added in the Criminal Procedure Code 1973 by the Code of Criminal Law Amendment Act 2005, is contained in section 265A to 265L. Remember that plea bargaining is starting from 265A to 265L, that is Plea bargaining. It is a new chapter. It may be a 21A or I think so. Okay. Now a magistrate may under section 252 or 255 of CRPC convict the accused of any offence triable under chapter 20. Okay. Chapter 20. Now, section 30, question number 34. In which of the following cases the Supreme Court held that FIR was not substantive evidence and could only be used to corroborate its maker? That is C. Mangesh versus State of Kerala, AIR 2010. Okay, the answer is D. C. Mangesh versus State of Kerala. In summons cases and inquiries, memorandum is the only record of evidence. Okay, memorandum is the only record of evidence in summons cases and inquiries. Now 36, if the accused is not acquitted under section 232 of CRPC, then the court calls upon him to enter upon his defense. Question number 36, answer is option number A. Now 37, in case of anticipatory breach of contract, an aggrieved party may, the answer is A, has the right to claim performance at any time. The aggrieved party has the right to claim performance at any time. Which of the following statements is not correct? Please concentrate on the question very carefully, that which of the following statements is not correct. That means acceptance must be in writing. It is written nowhere that acceptance must always be in writing. Okay, there under section 8 of the Contract Act, one can accept express his acceptance by performing a condition precedent. Okay, that is the question here. So these acceptance must be in writing is wrong or not correct. Now question number 39, the principal restitution stops where repayment begins can be applied against a minor only. Okay, now question number 40, promissory estoppel is sometimes spoken of as a substitute for consideration. Promissory estoppel is sometimes spoken for as a substitute for consideration. 41, a change of nature of obligation of a contract known as novation. Nature of the change, if there is a change in the nature of the contract, that is called novation. What does the word recession means? Recession means cancellation. And under section I think it's 68, there is what has been said, three words have been used. These are what? Novation, recession and alteration. Okay, novation, recession and alteration. Now 42, a notice in the newspaper inviting tender is an invitation for negotiation. Notice in the newspaper inviting tender. It is not issuing tender. Notice in the newspaper inviting tender is an invitation for negotiation. Now examine the following statements. Every contract is an agreement. Well and good, correct. Every agreement is a contract. No, it is not. Every agreement is not a contract. Wrong. Every lawful civil obligation is a contract. No, that is also not correct. Every lawful civil obligation is not a contract. Every contract has a legally enforceable civil obligation. This is right. So 1 and 4 is right. Option number A is correct. Now coming to question number 44, Union of India versus Madala Tataya is an illustration where the tender was in the form of standing offer. Union of India versus Madala Tataya is a very important case law of the Contract Act, explaining the problem of the standing offer. Now the rule laid down in Adam versus Linsell was approved by the House of Lords in Dunlop versus Higgins. These are also very important case laws. I suggest you please note this name of the case laws and read it in detail for the purpose of your mains examination. Okay. Now, which one of the following agreements is held to be opposed to public policy? An agreement of payment of less salary is opposed to public policy. You can go through the all other options. I am not reading every option because of the length of the video will be much longer than I intend to make it. Okay, so you can go it. Just pause the video and read all the options. Okay. Now coming to question number 47. What is the 47? Now, the facts of Griffith and Bryan would attract section 20 and facts of Carl versus Henry attract section 56 of the Indian Contract Act. Okay. Carl versus Henry, section 56 of the Indian Contract Act 1872, and the facts of Griffith versus Bryan would attract section 20. Now 48, the obligation to restore advantage in a void agreement is provided by section 65 of the Indian Contract Act. So obligation to restore advantage in void agreement is provided by section 65. Question number 49 says a continuing guarantee under section 130 is revocable as regards future transactions only. Okay. So the guarantee of continuing guarantee is revocable as to future transactions. Okay. Now coming to the for the purpose of pledge, question number 50, for the purpose of pledge, delivery of possession of goods has to be actual. For the purpose of pledge, delivery of possession of goods has to be actual. 51, a valid lease can be determined by a flux of time. Okay, a valid lease, this is a valid lease, can be determined by a flux of time. Okay, there can also be dash by estoppel, that is sale by estoppel. Question number 52, sale by estoppel. 53, causing of death of child in the mother's womb is not homicide as provided under explanation 3 of 299 of the Indian Penal Code. Okay. Now question number 54, coming to question number 54, section 511 does not apply in case of attempt of murder, because for the purpose of attempt of murder there is a specific section there in the Indian Penal Code. Okay, assault cannot be caused by mere words. Section question number 55, answer is B, assault cannot be caused by mere words. 56, personing a public servant is an offence under section 170 of the Indian Penal Code. So impersonating a public servant or personating a public servant is an offence under section 170. 57, the Supreme Court of India has observed a clear distinction between dishonestly and fraudulently in the case of Vimala Devi versus Delhi administration. Very important case, Vimala Devi versus Delhi administration. And 58, question number 58, the minimum duration of imprisonment provided for an offence under the Indian Penal Code is imprisonment for 24 hours. Under which section? You have to remember the section also. 24 hours, you can you may not have to work hard for the purpose of remembering that minimum punishment is 24 hours. But what is the section? This is section 510, which mentions that 24 hours is the minimum punishment which can be awarded by the court. The principle underlying in section 95 of IPC is de minimis non curat lex. That means law will not take notice of trifling matters. Question number 55, answer is option number A. 60, section 97 of IPC expressly states that the right of private defense is subject to the restriction contained in section 99. Okay. Now coming to question number 61, the language of part 3rd of section 105 is similar to that of section 39 of IPC. Okay, which of the following section of IPC has incorporated in the English law known as principle in the second degree, that is section 114. Which of the following sections of IPC has incorporated in English law known as principle in the second degree? Always remember it is section number 114 of the Indian Penal Code. Now definition of criminal conspiracy in section 120A of IPC has been taken from that given in Quinn versus Latham. Okay, so definition of criminal conspiracy under section 120A of the Indian Penal Code has been taken from that given in the case of Quinn versus Latham. This is a very important question and good question. This is a good question. Now question number 64, homicide cannot be defined as killing of a person by a person in view of the nature of the definition of the word person in section 11 of the Indian Penal Code. So where is the word person defined in the Indian Penal Code? It is under section 11 of the Indian Penal Code. The requirement of possession has been highlighted by illustrations. Which of the illustration of section 378 dealing with theft? The illustrations are C, D, E and F. C, D, E and F are the exact illustrations where the requirement of possession has been highlighted by these illustrations. Okay. Section 66, theft under Indian Penal Code differs from larceny in English law, which contemplate permanent gain and loss. So the difference between theft and larceny, that is permanent gain and loss. Okay. Now coming to Question number 67. Okay. A instigates B to murder C who refuses to do so. Very easy question. A is guilty of abetment to commit murder. Question number 68. Which one of the following brings out the distinction between 34 and 149 of the IPC? That is, section 149 creates a specific offense, whereas section 34 does not create a specific offense. Section 34 is only a rule of evidence, whereas section 149 creates a specific offense. Okay. Now, the question number 69, the Code of Civil Procedure Amendment Act 2002 permits the evidence in the form of affidavits. Okay, affidavits. It has been added in by the amendment of 2002, the Code of the Civil Procedure. Now, question number 70, it has been held by the Supreme Court in R.M. Malkhani versus State of Maharashtra that a contemporaneous tape record of a relevant conversation is a relevant fact. It is, why it is a relevant fact? Because it comes under the provision of the res geste, that is section 6 of the Evidence Act. You can go of any of your textbook, and under the comment section or discussion section under section 6 of the Indian Evidence Act, you can find that case. It is a very important and famous case, RM Malkani versus State of Maharashtra. Okay, now section 11 of the Indian Evidence Act enables a person charged with a crime to take what is commonly called as the plea of alibi. Okay, plea of alibi or alibi, whatever you may call. Now 72, a judicial admission operates as a waiver of proof. A judicial admission means an admission before the honorable court. So if someone admits something before the honorable court, then there is no proof is required in that case. So that's why it is a waiver of proof. Now, coming to question number 73, the burden of proof means the obligation to prove a fact. This much is clear. Now, this is defined under which section? It has been defined under section 101 of the Indian Evidence Act. Okay. Now, 74, the principle stated in section 106 of the Indian Evidence Act is an application of the principle of res ipsa loquitur. That means things speaks for itself. Section 106 of the Indian Evidence Act, okay, and resembles with the doctrine of res ipsa loquitur. That is, things speaks for itself. Question number 75, a leading question can always be asked, a very easy question, that is in cross examination. Okay, a leading question can be asked in cross examination. Now, coming to section 76, alibi is governed by section 11 of the Indian Evidence Act. Now, admission made by a party are evidence against previous in a state. Admission made by a party are evidence against previous in state. Now, question number 78, there is a confusion. Now, communication made without prejudice are protected. Communication made without prejudice are protected. Now, these are the provisions, and the section numbers are given here. It may be by mistake. These sections will be 121, 124, 123 and 122. Now, if we go by that sense, the answer will be option number B, 124 of the Evidence Act. Please read from your Bear Act or the textbook of the Indian Evidence Act all these four sections. These sections are very important: 121, 22, 23 and 124. Okay, now 79, necessity rule as to the admissibility of evidence is contained in section 32 of the Indian Evidence Act, where there is 8 clauses, and starting from the dying declaration, then course of business and the customs. Okay, there are eight provisions, subsections under section 32 of the Indian Evidence Act. Okay, so necessity rule as to the admissibility of evidence is contained in section 32. What is the necessity rule? Necessity rule says that the best evidence available must be brought before the court. So in case of a dying declaration, that person cannot be brought before the court, then his last statement is the best evidence, and just because these are his last words, these very thing that these are his last words puts a sanctity on that last words, that it will be genuine. Okay, now there is a brief elaborate discussion on that point, why it is called a necessity rule. Now we will discuss is in another video. Okay, now question number 80 says the res inter alia acta is receivable under section 46 of the Indian Evidence Act, which says if the opinion of the expert is relevant, then anything which are in support or which reviewed those opinions or the base of the opinion, all those things will be relevant under section 46 of the Indian Evidence Act. Okay, section 92 of the Indian Evidence Act applies to, always remember, these are bilateral contracts. Okay, these are bilateral contracts. 82, question number 82, estoppel should be specifically pleaded. Estoppel should be specifically pleaded. 83, Zahira Sheikh was a prime witness in Best Bakery retrial case 2006. Always remember, Best Bakery case is 2004, but Best Bakery retrial case is 2006, and Zahira Sheikh was a prime witness in Best Bakery retrial case. Now coming to question number 84, that is, I'm extremely sorry for the inconvenience, just a minute. Okay, question number 84 says the presumption under section 41 of the Evidence Act is a rebutable presumption of law. So presumption under section 41 of the Evidence Act is a rebutable presumption of law. Now pecuniary jurisdiction of the court has been dealt with in section 6 of the Code of the Civil Procedure. Now 86, question number 86, section 20 of CPC does not apply to arbitration proceeding. It has been clearly laid down in the Bare Act that to the arbitration proceedings this provision will not be applicable. Okay, now question number 87, 87 says under order 4 rule 1 sub rule 1 of CPC, a suit is instituted when a plaint is presented in duplicate presented to the court or proper court. Okay, now proper officer of the court, a plaint in duplicate is presented to the proper officer of the court. Now the options given here are: a plaint is presented to the court, a plaint in triplicate is presented to the court. So which one would be the best option available is a plaint in duplicate is presented to the court. Now 88, a suit in representative capacity can be filed by virtue of order 1 rule 8. Okay, 89, list of witness after settlement of issues must be filed within 15 days. 90, pleading can be altered or amended under order 6 rule 17, and remember that order 6 rule 1 says pleading includes both plaint and written statement. Okay, always remember that fact. Okay, 91, question number 91 says a suit can be dismissed in default under what? Under order 9 rule 3 and order 9 rule 8. In both cases a suit can be dismissed for default. One is for the non-appearance of the plaintiff and one is for the non-appearance of the defendant. Now an application under order 9 rule 7 of CPC can be made at any time on or before the next date of hearing. So an application under order 9 rule 7 of CPC can be made at any time on or before the next date of hearing, that is setting aside of the order. Now 93, question number 93, a judgment on admission can be given under order 12 rule 6. Okay, always remember the order 12 deals with the cases of admission, and judgment on admission can be given under order 12 rule 6. Now judgment and decree have been dealt in CPC under order 20. Judgment and decree have been dealt in CPC under order 20. Now coming to another provision, 95, provisions relating to interpolated suit are contained in order 35 of CPC. Provisions relating to interpolated suit are contained in order 35 of CPC. 96, order 12 rule 8 of CPC pertains to notice to produce documents. Order 12 rule 8 of CPC pertains to notice to produce documents. Under which section of CPC the principles of equity, justice and good conscience are prescribed? Section 151. Okay, now coming to the last 4 questions, that is question number 98, which one of the following decision is not a decree within the meaning of section 2(2) of CPC? That is award of tribunal in land acquisition case. Okay, award of tribunal in land acquisition case. Which of the following is a suit of civil nature? That is B, suit for accounts. Which of the following is a suit of civil nature? That is B, suit for accounts. You can go through all of the options and then you can read the answer, and we'll understand. You will automatically understand why I chose this answer. Okay, now the last question, the material fact on which a party relies are called facta probanda. There are 2 kinds of facts, facta probanda and facta probentia. Okay, so these are the 100 questions of the Jharkhand Judicial Service for the year of 2000, I think it is 15. So please like, share and subscribe my channel. I'm not so much well acquainted with the YouTube language or YouTube speaking, but I'm trying my level best, and I have intention to upload the 2014 and 2018 and 19 questions just like in this manner. So please support.